around, all I could see was sled cars, lowboys with tractors on them and everything coming down the road, coming this way.
Right now, we're going to place you under arrest for growing hemp without a license.
I was basically treated like I was a drug dealer, and I'm just growing a normal crop.
They were looking for somebody to use in a prosecution because there are certain elements of state government that are opposed to growing hemp.
Did you and your agency conspire to arrest this man and destroy his property?
Jody, I've already told you I'm not going to answer any questions about anything that has to do with this pending litigation.
The evidence we've got is a hell of a lot more evidence showing they willfully violated Trent's constitutional rights more than Trent ever willfully violating the Hemp Act.
A South Carolina farmer is continuing his fight against the state law enforcement division. SLED agents destroyed his hemp crop in 2019, charging him with growing hemp in a different field than he originally planned to use.
After prosecutors dropped the charge, the farmer sued, and the farmer later accused SLED Chief Mark Keel of discovery abuses in that lawsuit. A judge sanctioned the SLED chief and then ordered him to pay the farmer's legal team $11,000.
The chief appealed and lost and now has to cut the farmer a check. Here's Chief Investigative Reporter Jody Barr with an update to Seize and Destroy, a Queen City News investigation.
All Trent Pendarvis could do was watch as a pack of SLED agents mowed down his hemp crop. This SLED body camera video shows Major Frank O'Neill, the agency's head narcotics agent, hand chopping the farmer's crop as another agent smiles while he video records the major.
The rows were run just like these corn rows were run now.
The state ag department awarded Pendarvis a hemp grower's license just 4 months before the SLED raid. In his application, Pendarvis told the state he planned to plant his 40-acre hemp allotment in different fields, but by the time planting season came, he had to change his plans.
In the game of farming, necessarily your intentions to plant a certain crop in a certain field don't always work out because you're fighting the weather. You might be too dry, might be too wet. Things change in the game of farming a lot. The field that was intentionally was going to get the hemp planted in, it got real wet and got underwater, so we had to move it to a different location.
When the ag inspector showed up to his hemp field for a final inspection, Pendarvis says he told her he needed to change his coordinates on his initial application. The ag department sent him an amendment form, but later would not allow him to amend it and asked SLED to open a criminal investigation. SLED's first move, they asked the Attorney General for a legal opinion on how to enforce the Hemp Act. This August 8th, 2019 email between SLED Major Frank O'Neill and ag official Derek Underwood shows SLED knew the law on enforcement was not clear. We're having difficulty in what to address with so many gray areas concerning enforcement. We don't really have a comprehensive regulation that addresses all of the possible concerns. We're having to get AG opinions along the way, and the last thing we want to do is an action that will be perceived in a negative light by the media or General Assembly. The day O'Neill sent that email, the Attorney General issued this legal opinion telling SLED the act was not drafted with the greatest clarity. The act does not specify what procedures SLED must follow to enforce the law, adding, "Our office advises that SLED proceed with the utmost care to fully ensure that the grower and all interested parties receive due process in any enforcement action." The emails McLaughlin turned up shows SLED initially attempted to comply with the AG's opinion. This September 11th email shows SLED attorney Adam Whitsett asked Dorchester County Circuit Court Judge Diane Goodstein to meet them and sign a seizure and destruction order against Trent Pendarvis and his hemp crop. A few hours later, Goodstein's law clerk told SLED the judge would not sign it. But if SLED wanted a hearing in open court to argue why she would be glad to give you one. SLED's attorney turned down Goodstein's offer to be heard.
Look, they tried to go through the proper steps, right? They went to the Attorney General and said, hey, we think maybe we're entitled to destroy this farmer's hemp crop. How should we go about that? The Attorney General told them. They didn't like that. They went to the judge, and they, without showing the judge the Attorney General's opinion, and said, Judge, we think we're entitled to destroy this man's hemp crop. Judge said, you might be. Let's have a hearing. They didn't like that. They wanted to go around that.
Emails turned over to Pendarvis's legal team show 8 days later, SLED went to the county magistrate's office and left with an arrest warrant for Trent Pendarvis. The magistrate's records show SLED did not tell the lower court judge of its plans to not only arrest Trent Pendarvis, but to seize and destroy what Pendarvis believes was a $2 million crop.
That was only an arrest warrant. That magistrate had no authority to order the destruction of that crop, and the magistrate did not order the destruction of that crop.
But all these people knew it. They had been warned, specifically warned, if you don't do it right, you're going to violate his constitutional rights, and they didn't care.
John Trenton Pendarvis versus...
During a virtual hearing in October 2022, Trent Pendarvis' legal team spent more than an hour presenting evidence it says proves SLED hid evidence from the farmer before SLED raided his farm, and that SLED tried to mislead Judge Goodstein.
The defendant's conduct in this case was not just obstructionist discovery conduct meant to obstruct the plaintiff from getting discovery. It was also meant to mislead the plaintiff. And quite frankly, it was also meant to mislead the court.
In a 31-page order handed down last year, Judge Maite Murphy ordered SLED Chief Mark Keel to pay attorney Patrick McLaughlin a fine of $11,300 for the extra work and delay Keel's discovery misconduct caused. The judge wrote, Keel's written responses to the Pendarvis lawsuit are examples of his intentional, willful, and bad faith nature of Keel's discovery conduct. Failing to properly respond, ignoring written notifications of deficient responses, forcing the plaintiff to file motions, forcing the court to schedule hearings, and then, at the last minute, attempting to cure the deficiency is not conducting discovery in good faith and is evidence of intentional, willful, and bad faith conduct. I find that the prejudice to the plaintiff from Keel's conduct is clear, convincing, and substantial. Basic discovery in this case has now been delayed for over a year. Chief Mark Keel, who is also a licensed attorney, first joined SLED 45 years ago. Former Governor Nikki Haley gave Keel the chief's job in 2011, where he finished his first 6-year term. Hey, Governor.
How you doing?
I'm Jody Barr.
I bet you are.
Governor Henry McMaster reappointed Keel as chief in 2018, and just last month, the governor reappointed Keel to another 6-year term. As SLED chief,
Governor, Lieutenant Governor.
Mark Keel is also a member of Governor Henry McMaster's cabinet.
Thank you.
We found the governor at this public event last year, the month after the judge sanctioned the SLED chief for discovery abuses in the farmer's lawsuit. What do you think when you read that about a cabinet appointee?
Well, that's what the judicial system's for. As Paul Harvey says, no, that's the rest of the story, you know. I think that's what the judicial system's for. And it sounds like the matter is going through, it's a civil matter, and it's going through the judicial system.
And in the judge's order, she writes, I find that Keel's conduct regarding discovery in this case has been dilatory, prejudicial, willful, intentional, and in bad faith, and that his responses have been false, misleading, and incomplete.
Yeah. Well, I read some of those words, but again, that's the judge's order, and she's doing her job. Chief Keel has been in law enforcement a long time. He has a terrific reputation. His whole organization does. But again, this is a civil lawsuit, and it's going through the proper steps.
During our investigation into the hemp farmers' lawsuit, law enforcement sources sent us this: SLED's truthfulness policy, a policy ordering that agents shall be truthful and use complete candor in all official matters, whether in the course of employment or otherwise, unless deception is part of a necessary and approved investigative pretense or undercover operation. The policy goes on to order employees shall be truthful and complete in all written and oral reports and statements pertaining to division business and related activities. The truthfulness policy went into effect in 1992, a policy that applies to every SLED employee, a policy enacted and ordered by SLED Chief Mark Keel. SLED has a truthfulness policy. Truthfulness policy? And it was signed by Chief Keel. And it says in that policy, employees shall be truthful and use complete candor in all official matters, whether in the course of employment or otherwise.
I understand. And of course, there are always two sides to every story, and that's what the judicial system is for. Chief Keel has been a respected law enforcement officer for many, many years. I've worked with him for many, many years. I have confidence, high confidence in him. Of course, the judge has a good reputation, but that's what the legal system is for, is to sort these things out in a methodical procedure that is set by law, and that's what's happening.
Who should hold Chief Keel accountable for what this judge has found?
You ask that same question.
Well, who holds him accountable? I mean,
well, that's what the judicial system is for.
Chief Keel appealed Judge Murphy's sanction to the state appeals court, asking that court to undo the order. But the court dismissed the chief's appeal. Keel then appealed to the South Carolina Supreme Court, who last month upheld the appeals court decision to dismiss his appeal. 2 weeks ago, the SLED chief paid the $11,307.36 sanction.
What we want to ask about,
I'm not going to answer any questions about anything to do with that pending litigation.
Did you and your agency conspire to arrest this man and destroy his property?
Jody, I've already told you I'm not going to answer any questions about anything that has to do with this pending litigation.
Every step of the way, we asked SLED Chief Mark Keel to interview with us. Again, just this week, the chief refused to talk with us about paying the sanction, losing his appeals, and the judge's order now becoming the law of this case. Judge Murphy filed an amended order last month demanding SLED provide Trent Pendarvis's civil attorneys with all outstanding evidence by January 26th. With Chief Keel's appeals options apparently now over, the farmer's civil suit against SLED and the Ag Department continues in Dorchester County. Now, that typically means the work toward depositions and further discovery would continue, with the trial coming if both sides cannot settle this otherwise.